wait, so if I have a will and it outlines exactly how I want things to go, it still has to go through probate? And the answer is yes. And you just have to remember that sequence. Wills take effect when you're dead. When you're dead, you lose that signature. And if you can't sign and transfer your assets, it's got to go to court, and the court steps in to oversee the transfer of assets.
Jim, I am so excited that you are here. I've been looking for you for so long. And so I'm so glad that we've met up around this, because I know our viewers want to know about estate planning. And our viewers are all over the country. And so to find someone like yourself and your team that can help people across the country is wonderful. So what I hope you're able and willing to do today is kind of give us an estate planning 101.
Yes.
I've got some practical questions around how it actually works, because I did lose my mom within the last 6 months. And we went through this whole thing. So I'll have actual, here's how it worked for us questions. Right. But yeah, maybe you could take us through estate planning. Who needs it? What is it? What are we looking at here?
Absolutely. Well, I'm so glad you found us
Yes.
as well. So that's a definite mutual feeling there. So thank you for letting me be a part of this today. We're super excited. So
And you've already helped some people, which is wonderful.
It's been great. And those that we've been able to chat with, they're just fantastic. So you've got a great following, and the people that are following you are great. And I know that there's a lot of DIYers that we love that they get after it. So that's actually really, really great and awesome. So yeah, that's perfect.
So take us through. What do we need to know about estate planning?
Perfect. You know, it's interesting. So I've been in this world for a long time. You know, I started back in 2001, hence the gray beard coming on in here. Oh, goodness, I've been doing this for a long time. Now, just as a little bit of background of me. So I started working at an estate planning law firm, and I learned something very quickly. I learned that everyone needed to get their estate planning done, and they wanted to get this done. But when they got quoted the price, a lot of them ended up walking right back out the door. And I got thinking to myself going, and I remember talking to one of the attorneys, and I said, this is a pricing thing. You know, why don't you give them a discount? I said, if you give them a discount, they'd totally do this. And he's like, well, the problem is if we give them a discount, then they're going to go tell their friends and family. We're going to have to give them a discount. Then they're going to tell their friends and family. And then we're essentially going to shoot ourselves in the foot and devalue the product. And so I said, well, I get it. And then I thought to myself going, well, why don't we do more of like an educational aspect of this? Like, you guys can still draft the documents, but what if we took more of an educational or an online approach? And then, people could fill out the questionnaire, get a lot of education, but then at the end of the day, they're still getting state-specific attorney drafted documents. And he was like, well, yeah, we can totally do that, but nobody's going to do that. Now, this is the early 2000s, so the internet was not what the internet is today. And because of the price point, it just kind of took off. With doing that. And so anyhow, lots of years later now, and so now we're set up where we've got things structured. And we've got we're able to do this on a national platform, and all of our documents are all state specific attorney drafted. But a lot of people, going back to your question, is they go, well, what is estate planning, and what do we need to know? Estate planning, like the term estate, the easiest way that I tell people is it's your stuff. And I know that sounds kind of strange when I say it like that, but it's your house and your bank accounts and life insurance or retirement, your cars. That's your estate. And what we're trying to do is we're trying to plan what happens to your stuff when you pass away. So that's probably an easier way to look at that, because estate sounds like so grandiose and like, oh my gosh, I got to be a multimillionaire in order for this to make sense. But it doesn't. It's passing your stuff on to whomever you want it to go to, and trying to keep the court out of that process is really what we're trying to accomplish.
No, that's great. And it seems like you're going to be planning around it, and there are informal things that you can do for this plan, and then there are formal legal things that you can do to make sure that plan gets executed. So I guess, what are the options people have? In my mind, you can do nothing, or you can do kind of more the legal official steps.
You're spot on. So again, we like to keep things really easy, hence the name, Easy Legal Planning. We like to try to keep things really simple and easy. And so we teach people, really, you have three options. You can do nothing. That's option number one. You can do a will. That's probably the most popular one that people have heard of. Or you can do a revocable living trust with doing that. And people, a lot of times, they go, well, I already fit into category number one. I haven't done anything. And they go, what happens? Like, if I were to drop dead today, what happens? Well, a lot of people don't know, but when you pass away, the state that you live in, they have a will for you. It's called an intestate will. And people go, really? That the state has a will for me? I'm like, yes, but the problem is the state's going to make all the decisions for you. So if you pass away and you don't have any estate planning done, the state's going to name your executor. They're going to name your beneficiaries and how the money gets to them. And if you have minor children, they're going to name guardians for your minor children. And those are big decisions. And a lot of people are like, I don't want the state making those decisions. And I'm like, no, me neither. And that's why it's important to do something with that.
With the state making those decisions, I'm assuming there's some sort of a legal structure that they're using to make those decisions, right? It's not just willy-nilly, We're going to throw your kids to someone. Do you know, it probably varies by state, but how are they figuring out what to do if you don't do anything?
Yeah, normally what happens, and again, like you said, every state is a little bit different with their intestate laws and their rules of how they do that. But in general, it's going to what are called your heirs at law.
Okay.
So that a lot of times means like if a husband and wife passed away and they have children, again, their heirs are their children. So the money's going to go to their kids. Now then they look at it and they go, well, are the kids over 18 or under 18? So there's a lot of variables that kind of come into play there. And then if you don't have any kids, then they go, okay, well, are your parents alive? And if your parents aren't alive, then it goes to brothers and sisters. And if they've had a sibling that died, then their portion goes on to the nieces and nephews. So there's kind of this hierarchy of that. But every state is a little bit different with exactly the specifics. But again, a lot of times we like to teach people, whatever it is the state has, probably still not the very best. I mean, you're losing control and you're no longer in the driver's seat, and the state's going to be the one making the decisions.
For sure. And it's easy. I think it's easy in my world, right? It's easy for us to say everybody should do this or everybody should do that. Is there a place for somebody to just do nothing? Like, is there a circumstance that makes sense?
Great question. Actually, really, really and truly, yes. We've had clients over the years that, there's one that coming to mind. She was a widow. Her spouse passed away. She ended up moving in with her kids. And so she had no real estate. She goes, I have one bank account and I've got 2 surviving children and I've already named them as the payable on death designate. I've got my 2 kids named. And she said, I've got some personal possessions that, my kids can essentially have. But other than that, she was like, I don't think I really need anything. And so I said, well, the way that, you have everything set up with, beneficiary designations essentially is perfect. I said, that's really, really great. But we talked about, I said, if you want to, you could actually handwrite your wishes. It's called a holographic will. And she was like, what? I can just handwrite it? She said, do I need to have it notarized? And I said, actually, you don't. As long as it's in your handwriting and you sign and date it, those are going to be your wishes with that. But we did talk about the importance of powers of attorney. So even though she didn't really need like a will or a trust or something along those lines, we talked about, what if you slipped or you were unconscious or you got Alzheimer's or dementia or something went sideways like that. It's important to have those tools in place to allow your kids to step in and take things or take those matters into their own hands instead of, again, having to go to court.
I love that. I love that there is a place for it of those who can just do nothing, because I feel like, again, we do have a lot of DIY people that are...
Yeah, and there's another scenario as well. I had another client that they were young. They're really young, just graduating from college. So it was a newlywed. They had no kids. They had no real estate. They really didn't have any assets. And they're like, do we need to do an estate plan? And, again, we were like, well, at this point in time, probably not. With doing that. And now when you guys start to have children, yes, absolutely. Or if you decide to buy a home, absolutely. Or if you do start to get some assets that are a little bit more substantial, then absolutely. If you feel like it's appropriate to make those designations of where you want things to go. So those are a couple of situations where you're like, you know what, you can use beneficiary designations. If you want to write a holographic will, do that. And then we always encourage people to have those powers of attorney because those are important tools.
Great. That's getting into, I think, a little bit more of the official planning now. So maybe we can move into that. And you had said, so there's do nothing and now there's a will. So let's move into a will.
Perfect. Let's talk about the will. Now, the will is the most common or popular option that's out there. And people ask me, they go, why is that? And I tell people, I go, well, think of pop culture. Like if you watch movies, TV shows, they always talk about like, oh, this person died and luckily they had a will. And
Taylor Swift.
Right.
She thinks I left him in the will.
Right. Perfect. Hey, good reference. Yeah. But that's exactly right with doing that. So we just all kind of grow up going, well, if I'm going to plan how I want things to go and I die, I need a will. And they don't really know that there are other options that are out there. But people ask and they go, well, what would I be doing if I set up a will? And the answer is you're really doing 3 things. you're naming your executor. So that's kind of the money manager that it's going to step in and carry out your wishes. You're naming beneficiaries. So those are, the people that you want the money or the assets going to, the ones that will benefit from your assets. And then if you have minor children, you're naming guardians for minor children. So when you set up a will, that's really what you're doing is you're outlining or mapping out who controls the money when I die, where's the money going to go, who gets custody of minor children. And a lot of people ask and they go, well, perfect, that's what I want to do. Let's do a will. Well, here's a big misconception because people think that as long as you have a will, you're good to go. Now, there's a really important concept that I always like to teach people, and because this is what everything revolves around. So I always tell people right up front, I'm like, everything in the estate planning world, it all revolves around signatures. And they go, well, what do you mean by that? And I'm like, well, think of it like this. I said, don't overcomplicate this. I'm like, while you're alive, you can do whatever you want with any of your property and assets because you can sign on the dotted line. So if you wanted to go in the bank today and you needed to withdraw some money, again, no problem because you're alive and you can sign on the dotted line. But where a lot of people don't totally connect the dots just because they're not thinking about it is people don't realize that when the time comes that you die, your signature dies with you. And if you're still listed on the title of your house, you can't sign that deed over to the executor. Or if you're still on your bank accounts, either as an individual or as joint owners or whatever, if you're dead and you lose that signature, you can't transfer your bank accounts over to your family or loved ones. So it has to go to court and go through probate. So then people go, wait, so if I have a will and it outlines exactly how I want things to go, it still has to go through probate? And the answer is yes. And you just have to remember that sequence. Wills take effect when you're dead. When you're dead, you lose that signature. And if you can't sign and transfer your assets, it's got to go to court, and the court steps in to oversee the transfer of assets.
What does that look like? What does probate look like for people?
Yeah, great question. Really what's happening, again, very simply put, really what's happening in probate is the court is stepping in to represent the dead people. The court basically steps in and they say, okay, husband and wife died or individual. They're no longer alive to sign and transfer these assets over to their family. So we as the court, we're going to step in and we're going to represent that deceased person. Now, again, at that point in time, the court's going to go, do they have a will of their own, or are we using the state's will, that intestate will? And then again, depending on if they have a will or don't, that's the direction that they're going to go. But really and truly, probate is essentially the court just stepping in to represent the dead people, and then they're going to oversee the transfer of assets because the dead people can't sign on the dotted line anymore.
It seems like the will is kind of like instructions then, right? So here are the instructions, court, of what I wanted. Now that I'm not around, execute those instructions, but the will is still going through probate, going through that court. Is there, do you know, again, it's going to vary, but is it a long time in probate? Is it
Great
short
questions.
time?
The AARP did a study, and they said they did two things. They wanted to know the average time and the average cost. So, and again, this is a national, survey that they took. So the national average time frame of a probate is 9 months to 2 years. Wow. So pretty lengthy. Yeah. Pretty lengthy experience on that for the loved ones that are left behind trying to sell things or trying to get things in order. It's frustrating with that. And then cost-wise, it's typically about 3 to 8%. With that. So it can get expensive. And a lot of people, when they hear that, they go, well, it's not too expensive. But you go, well, if you added up your house and your bank accounts and life insurance and your retirement, if all of a sudden you lump those things together and people go, oh, I'm at $1 million. Well, you go, what's 3% of $1 million? They're like $30,000. That's pretty expensive. And people go, man, I'd rather have that money going to my kids.
Right.
I agree.
No, that's interesting. Are there things that people think should go in a will that maybe don't belong there and belong somewhere else?
Great question. Yes. Interestingly enough, when you say go into a will, people actually, that's probably one of the biggest misconceptions right there. Nothing goes into a will. You're mapping out your wishes, but the will never owns anything. You can't transfer things to a will. We're going to talk about a trust and how that comes into play, but that's probably one of the bigger misconceptions is people are like, oh, I'll just set up a will and I'll start transferring my assets to the will. And I'm like, well, you can't do that. So that's probably one of the biggest misconceptions right there is that you're not able to transfer your assets into a will. The will just simply directs where you want things to go when you pass away.
Gotcha. That's great. So yeah, including like I want my car in my will doesn't make sense. It's what happens to my car is an instruction.
Exactly.
Let's move on to the trust. We teased at it long enough. Let's talk about them.
Let's get into it. Yeah. So option number 3 is setting up a revocable living trust. Now, a lot of people, the knee-jerk reaction when we say, hey, you can avoid all this by setting up a revocable living trust, they go, I've always heard that those are for like crazy rich people, like multi-millionaire, and they're like, I wish that I were a multimillionaire, but I'm not, so I don't think I need a trust. That actually is another big misconception. Trusts are not just for the wealthy. Trusts are used all the time in really, really simple situations. And then people go, well, what would I be doing if I set up a trust? And the answer surprises people because, believe it or not, when you set up a trust, structurally, you're doing the same thing that you do when you set up a will. You're appointing who controls the money, where the money goes, who gets custody of kids. So you're still mapping out your wishes just like you are in a will. And then people go, what's the difference then? It sounds like the trust and the will are identical. So what's the difference? Well, the difference is this. As soon as a trust gets signed in front of a notary, it becomes a living entity. And that's why it's called a living trust. Now, most people have never heard of that. They're like, what's a living entity? Well, there's two things that I always like to teach people about living entities. I teach them, number one, living entities can own property and assets. So unlike a will, a trust can own assets, kind of like a human. And I know that sounds weird, but a trust, because it's a living entity, it can own real estate, it can own bank accounts, it can be named as a beneficiary on assets as well. So that's the first thing that you have to understand about a trust is because it's a living entity, it can own property and assets. Now, the second key thing that you have to understand about a living entity is living entities don't die. So even if husband and wife die or individual dies, the trust, because it's a living entity, it continues to live. And if it already owns the house and bank accounts, life, if it already owns all of those assets, well, now there's nothing to probate.
Yeah.
So that's really kind of the idea behind the trust is the trust is simply a tool that's allowing you to get all your ducks lined up in a row ahead of time. Because it all remember, it all revolves around your signature.
Yeah.
So we're just trying to get all these ducks lined up in a row ahead of time.
It kind of makes me think of a corporation almost, right? Where if a corporation, if the owner of the corporation passes away, well, you have a board that takes over.
Bingo.
And the corporation doesn't die because an individual died.
Correct. That's a great way of thinking about that. We have a lot of clients that'll say the same thing. They're like, oh, I set up a corporation and it's kind of the same thing. I'm like, yeah, it's it's a living entity, with doing that. So yeah,
that's awesome.
Perfect.
I do want to take a step back because we did this for the very first one, but when does just a will make sense?
If you don't own any real estate, then again, you start to fit more into that category of not needing a trust. Or if you don't have any minor children, then again, you may not need to have, or you may be able to just get away with having just a will with that. Because the two big categories that people are like, should I, do I need to go down the road of setting up a trust is, do you own real estate and do you have either minor children, disabled children, or do you want to control how that money gets to your kids? Because that's another thing. We have a lot of people that are like, well, if I pass away, I want the money to go to my kids, but I've got this one child that's kind of a little rogue, and if I give them some money, they're going to blow this, one way or the other. So setting up a trust for those types of situations makes sense. But if you don't have any real estate and all of your kids are adults and it's very simple, you've got some bank accounts or life insurance and you can put beneficiary designations on those, then that would be a great time for somebody to set up a will.
That's great. And when you start talking real estate, like in my mind, I'm like, oh, a real estate investor, but really that's a house, right? Like that's just as simple as a house,
primary
a townhome,
residence.
anything as simple as that on up to a lot more things.
Right.
Can make sense with that. So let's talk about the trust and structuring that. You talked about more control. What are some things I have a little bit more control over in a trust? How do I get that officially done? And then moving on to actually implementing that.
Perfect.
trust.
Love it. One of the big things, and this is a huge advantage of a trust, is you're able to control the distribution. Because typically in a will, you're basically saying, hey, if I die, these are my beneficiaries. And then as long as they're adults, that money goes to them. But in a trust, and this is great for parents that either have minor kids or kids that may blow through money a little quicker than they may want them to. You can structure the trust in a way that says, okay, if we die, yes, our kids are the beneficiaries. However, we want some rules. So that way, maybe they get a little bit of money, at age 21, or maybe they get a little money at 27, and then they get the remaining balance when they're 35 and they're a little bit more established and mature. So that's one really cool thing about a trust is you can make those types of stipulations and rules, and people really, really like that. So people that have minor kids or people that have disabled kids as well, that's another really big reason that the trust is hugely advantageous is you get to control when, where, and how that money gets to the kids.
How specific can I get with that? Can I say like, okay, son, when you turn 18, I'm going to give you X amount of dollars specifically for college. And then I can give you this amount of dollars specifically for a wedding.
Yep.
So you can get that precise.
Yep. You can be very, very precise on doing that. Now, a lot of people ask and they go, do most people do that? Interestingly enough, I would say probably not. People don't like to get too far into the weeds. Most people are like, you know what? I want to, give some guidelines, but the people that I'm naming to carry out my wishes, I trust that they're going to make the right decisions if they need to navigate a little bit more loosely with some of the things that they need to use the money for with the kids. But yes, you can get super
specific on like exactly where you want that to go.
Right.
That's
But you don't have to.
Yeah.
You don't have to either, but so it's up to you.
Let me ask you this, and this is coming again from personal experience with the family. So what does the executor of that trust need to understand as their responsibility? Because it became a big decision, and so what does that all look like? What are they going to do? What should they do?
Right.
Does that make sense?
Oh, absolutely.
Yeah.
And it's quite a bit. I mean, that's not like a light task that you're asking somebody to do, because normally what happens when somebody dies and the person steps in to implement that, first off, they're reaching out to all of the financial institutions to let them know that whomever has passed away, whether it's an individual or a couple, they're saying, hey, this person has passed away. Here are the death certificates proving that they've passed away. And then that's what they're doing. So they're reaching out to financial institutions to let them know, hey, this person has died. And then they're working with the financial institutions to then receive the funds.
And make payments, right? So if you have a home and you have utilities or anything else, it's not just, because that was my misconception. It's like, oh, money's just going to come in and we're going to distribute it. It's like, no, we still have bills we need to pay. We still have things that we have to deal with.
Yep. So there's still things that they have to do. So essentially, when you have a trust, now, normally, we're going to talk about this in just a sec, but when you set up that trust, one of the key components to having a trust is funding the trust, meaning transferring your assets into the trust while you're alive and you have your signature, so that when the time comes that you pass away, there's no need for the court to get involved because everything's already attached to that trust. So as long as that's been done, when the person that steps in, now I like to use the word executor because that makes more sense to people. Because sometimes when I use the technical term, they're called successor trustees. People are like, what in the world is a successor trustee? So anyhow, I like to use the word executor because it makes more sense to people because they've heard that more. But even if you do have a trust, the executor steps in and they're reaching out to all the financial institutions to let them know, hey, this person has passed away. Here's a death certificate. And then as long as that asset was attached to the trust, they're going to release the money to the trust. And then that executor is going to deposit the money into the trust account. And then they have to pay off any outstanding debts and tax or funeral expenses or kind of keep things afloat while they're getting things taken care of with doing that. And then once all the debts, taxes, funeral expenses are paid for, then they have to follow the rules of the trust. And that's kind of a big wide open gate because it depends on what the wishes of the trust are. Because the trust could say easy enough, like divide the money between the kids, and literally the executor cuts a check to each of the kids and they're done.
Yeah.
Or it could be, well, this child, you're going to have to manage that money until they're 35 years old because, they're still young and we want you to help them and pay for their college or schooling or whatever. So then there's a lot more involved on that because now they're on, they're going to be managing that ongoing.
Yeah, that's a lot to deal with. Luckily, my brother took care of this, right? So he's the one who's had
Lucky
to deal
you,
with,
right? Yeah, absolutely.
deal with all that. But if I'm assigning somebody a successor trustee or executor, whichever word we want to use, it's probably smart not to just assign them and not tell them about that and let them know what's coming and what's a part of that.
It's funny that you say that. We've had people over the years that are like, I don't want to tell them this. I'm just going to have this and I'm going to put it in my safe and then surprise. And I'm like, that's not a very good idea. Yeah. I mean, it's up to them to do it that way, but it's not. I mean, that's a big surprise, to be able to do that. So I'm always a big believer, and I tell people, be proactive so that the people that you name to step in aren't going to have to be reactive, because then it gets messy, it gets complicated. So in our documents, actually, our documents are broken into 8 different sections, and in section 8 we have instruction letters for the successor trustee, and it literally walks them step by step of what they would need to do if somebody passed away.
That's great. It's almost like they're another partner in this. Like if it's me and my spouse, well, my successor trustee is another partner in the family, whether that is a family member or not, which actually makes me think, It doesn't have to be a family member,
No.
right? It can be a friend. It could be a attorney. It could be a company that does all of this. Any of those options?
Any of those options. A lot of people ask and they say, are there any like hard, fast rules that, if I'm going to name a successor trustee or an executor, are there any rules that we have to follow? And the answer is yes. So they have to be an adult. So they have to be over the age of 18 and they have to live in the United States with that. Because some people will say, hey, I've got a family member, they live in another country. It creates some taxing issues. We won't get into that, but it creates some taxing issues. So we just say, you know what, make sure that that whomever you're going to name to carry out your wishes, that they're over 18, they live in the States.
That's awesome.
Yeah.
What's the difference between a revocable trust and an irrevocable trust?
Great question. So
And what makes sense for each?
Great question. Now, very high level, very simply put, is revocable means changeable, irrevocable means unchangeable. So when you're setting up a revocable trust, it means you can make changes. Life happens. Life throws us curveballs. And sometimes people set things up in a certain way. And then 20 years from now, they go, whoa, things have totally changed. With a revocable trust, we make those changes, no problem at all. With an irrevocable trust, you can't. So you're a little bit more set in stone. And a lot of people go, why would anybody ever do that then? If you're setting up this irrevocable trust, why would anybody do that? Well, irrevocable trusts are set up for very specific situations with liability protection, or sometimes like Medicaid situations. There's some obviously a space for them, but by and large, most people are doing revocable trusts. So if you talk to somebody like, oh, I have a trust, 9 times out of 10, or actually even probably higher than that, it's going to be a revocable living trust so that they can maintain control of their assets and make changes down the road as well. And that's, believe it or not, that's the only type of trust we do. We actually don't do irrevocable trusts. So if you're thinking you want a permanent trust for some of those other reasons, then we may not be the right option for you with doing that. But yeah, we just focus on revocable living trust because that's usually what makes sense for the majority of people.
I appreciate you pointing that out.
Yeah.
That's great. And that brings up an awesome point when you say that you can make changes. And I think a lot of our viewers, at least who have reached out to me, have said, hey, I put a trust together when I was in my 30s.
Yep.
I'm now approaching retirement. A lot has changed in there with kids, grandkids, properties, all of this stuff.
Mm-hmm.
How hard is it to change a revocable trust? And what does that process look like?
Great question. We deal with that all the time. So we have a lot of people, exactly what you just said. They're like, our kids were young when we set this up. Now we're almost retired. All of our kids are adults. We want to completely change things. So if they have a trust, we actually prepare what's called a restated amendment. And people go, what's that? What's a restated? Restated just means we're essentially restating or redoing that. And really what we're doing is we're redoing the documents so that they are compliant to like this current year. So it has everything's totally current to everything that's applicable now. And then we can also make any changes they want. So we can change their, successor trustees, their beneficiaries, guardians, powers of it. I mean, we can change everything. But the one thing that does stay constant when we're doing a restated amendment is the name of the trust and the date that it was signed and notarized. And people go, why? Why? So we have to keep the same name? And the answer is, well, ideally, you'd want to keep the same name and the same date of your trust. And they go, well, why is that? And the answer is, if you've already funded or transferred assets to this trust, we don't want to have to go back and unring that bell. You don't have to go retitle your property from an old trust to a new trust because it's expensive. Or you don't want to have to go into your bank or credit union or life insurance or retirement and then update everything to name this new trust. So we go, let's just restate the trust. We'll keep the same name, the same date. And then all those assets that are already funded in your trust, we don't have to touch them. Just leave them as is. But then the rules of the trust are now all current.
That's super interesting because I had a question on this, and maybe there's still somewhere to go with this, but it was if there were enough changes that I needed to make. Again, let's say I'm mid-30s, I've got one child, I'm married to my spouse, and now that I'm 60, I'm not married to that spouse anymore, or for death or divorce or for whatever reason. I've got 6 other kids, I've got properties, businesses, whatever else it is. Is there enough happening there to where it makes sense to just get rid of the old trust and start a new fresh
Great
one?
question. And in a situation like that, like if it was like a divorce or something, or there'd been drastic changes, it very well may make sense to just start over from scratch. And then even though they may have like, oh, well, these assets are still attached to that old trust, it's like, that's okay. Pull them out of the old trust and move them over into the new one. And it just takes a little bit more legwork, but that sometimes is the best option.
Perfect.
With them.
You've mentioned if you have special needs kids, what is I've heard the term special needs trust. I have a friend who's got a child who's special needs, and it came up. So what are the differences here that are happening?
Great question. So 2 things that are really important to understand when it comes to special needs trust. You have what are called first party special needs trust and third party. And I'll explain the difference. So a first party special needs trust is a child that has already received either an inheritance or a settlement. So they were either hurt, they got some money from a settlement, and they're holding a good chunk of change. Well, because they're now disabled, they still need to have state and government assistance. So you can set up a first-party special needs trust that still allows them to apply for a lot of these state and government programs that are available. Now, the only downside of the first-party special needs trust is a lot of times the state or government will step in and pay for their care, but as soon as that child with special needs passes, a lot of that money has to be paid back. So they go, well, you've already got a big chunk of change, and we've been paying you, for your life. So we want that back. So that's called the first party. Now, we actually don't do first party. First party special needs trusts are really, really specific, and you need to have a local estate planning attorney that's been doing this for a minimum of 10 years. I always tell people 10 years is, typically a minimum when we encourage people, hey, if you need to go sit down with an attorney, get one that's been practicing estate planning for a minimum of 10 years. Just because those first party special needs trusts, they have to be done a very, very specific way. Now, third party special needs trusts, these are probably more common. That means we have a husband and wife or an individual, and they have a child that has special needs, but that child hasn't received any money yet. So you're setting up this trust. So while the husband and wife or individual is alive, the trust is revocable, so they can still make changes or whatever they want. But then within the rules of the trust, it has this special needs trust language built in, so that when husband and wife die, now all of a sudden the money that's supposed to go to that child with special needs isn't just handed over to them. Because if it is handed over to them, then all of a sudden their benefits could get forfeited, and it can create some issues. And so that money is then set aside in a special needs trust and then managed by the trustee for that child with special needs. But that's called the third party special needs because it happens essentially after husband and wife die. The child is now that third party that's going to be receiving the benefit of that special needs
trust. Is that only for children? Could that also be for, like, if I'm in charge of a sibling or if I'm in charge of a parent? Is that going all kind of full life circle there?
Exactly. It could be. It could be anybody that you've essentially got custody or guardianship of, along those lines of somebody that's disabled, with doing that.
Perfect. So. With the trust, one more maybe question on trust, and then there's some other things I want to ask too. But with the trust, what are some common mistakes you see people make with a trust?
Great question. This is probably the key to everything. And I said the word before, which is funding. Mm-hmm. The transferring of assets. I cannot tell you how many times over the years we talk to people and they're like, oh, I have a trust. And we're like, oh, that's great. Congratulations. That's super. I'm glad to hear you got a trust. And then we'll say, have you transferred like your house and your bank accounts, life insurance? Have you attached those assets to the trust? And usually it goes dead silent. And they're like, what do you mean? And we're like, well, in order for the trust to function properly, you have to transfer your assets into that trust so that when you die, there's no need for the probate court to get involved to oversee the transfer of assets. That already happened. All those assets are already sitting in the trust. And they're like, I had no idea. No, we've never done any of that. So that's probably one of the things that we see over and over and over is people have these old trusts and they're empty. They don't own it. The house isn't in it, bank accounts, life insurance, retirement, none of the assets are in it. So if they pass away, it's essentially going to work like a will.
So how do you fund a trust?
Great question.
What does that mean?
Super. Yeah, so there are 6 categories of assets. Technically, there can be 7, but we like to keep things, again, simple and easy. So I teach people that there are 6 categories of assets that get transferred into the trust. Number 1 is real estate. 2 is bank accounts. 3 is brokerage accounts. 4 life insurance. 5 is retirement accounts. 6 personal property. And so let me just kind of briefly talk about each of those. So the way you transfer real estate into the trust is by recording a deed at the county where the property is located. So that's the way you do that. Now people go, who prepares the deed? Like, how do we get a deed to do that? We can either do it, or they could go to like a local title company and have them prepare a deed. But one way or the other, the title of the house has to get out of their names as, husband and wife, or if it's an individual, out of their individual name and move it over into the trust. Because again, remember, it goes back to that signature. So even if you had, like, let's say that my wife and I had this beautifully written trust, and my wife and I are on the title of the house as joint tenants. Well, if my wife and I die, we lost our signatures. We're no longer able to sign the deed over to the trust. So even if my successor trustee went in and said, hey, Jim and his wife have died, here's the trust, I need to sell the house. They're going to go, hate to tell you this, the trust is not on the title of this property. It's still in Jim and his wife's name. And since they're dead, they can't sign it. You got to go to court and go through probate. And then they're like, what? We have a trust. So then they have to go to court and go through probate.
Just to prepare on that, if I am doing something to deed the property into the trust, is there a cost to do that?
Great question.
Whether with you or
yes,
or with any other?
There actually is. Yep.
Okay.
So we charge $250 to prepare the deed, and then you've got your actual recording fee. Every county, every state is different with their recording fees. Most states, when it comes to recording fees, are between $10 and $50-ish. Most states. Now, there are a few states that are more expensive. So like the state of Washington, they charge like $314.50. That's just their recording fee. So then you have to think of that going, okay, $250 to have the deed prepared, $314.50 to record it. Again, but still that's way cheaper than probate or having to deal with the court on doing that. There's two things I do want to mention. The state of New York, we actually can no longer prepare deeds in the state of New York. When COVID happened, they changed their process of wanting things to be contactless. And so you have to be set up a very specific way. So any of our clients that are in New York, we just put them in contact with a title company, and then the title company will prepare it and help them do that.
So you can still do the trust for people in New York, or the will, or whatever else, but the deed itself.
Yep, that's exactly right. The deed itself is going to be done through a title company, just because of the regulations.
And I cheated, and I did look on your website, and something about Cook County, Illinois.
That's exactly right. I was going to say that was the other thing I was going to tell you. Cook County, Illinois. Cook County, they've just got some different rules and regulations when it comes to recording property, and they make it a little bit more difficult to do that. And so we don't do those anymore, because it's just so much easier to have a title company that does it day in and day out, and they know exactly what those little rules and regulations are. So it's easy for them. But so we just decided, you know what, it doesn't make sense, because it was taking too much time and effort to get those deeds done in Cook County. So we're like, you know what, let's just send them to a title company, and they can take care of it from there. So New York and Cook County, Illinois are the two places where we don't prepare deeds.
Perfect. No, I'm glad you clarified that.
Yeah.
And any other mistakes people make with a trust?
Great question.
Well, and you did say there were 6 properties.
Yes. Let's talk. Yeah. So let's talk about the
funding. With
the funding. Yes, the funding thing. So that is the real estate. Another thing that we get questions on all the time is people go, okay, so we're going to move, I'm going to record a deed at the county, and that's going to transfer the title of my house over into the trust. And the answer is yes. And they go, what if I want to sell my house? Am I going to run into problems? And the answer is no. When you move property over into a trust, you still own and control the trust. You're still on the title of your property. So absolutely, you could step in and sell the property. No problem at all. The other question that people ask is, they go, do I need to do anything with the mortgage? I still have a mortgage on my property. Do I need to reach out to my lender and update something with them? And the answer is no, because it's revocable. You're still on the title of the property. The loan stays the same. So you don't have to do anything. The only thing that a lot of times we do encourage people to do is to reach out to their property and casualty insurance company and tell them that they've created a trust and moved the title of the house over into the trust. And they just add the trust as what they call an additional insured. So it's more of like a courtesy of you calling your property and casualty insurance company and saying, hey, move property into the trust. Here's the name of our trust. Just add it as an additional insured to our policy. It doesn't cost anymore. It's just they like that, and they appreciate the update or the heads up on that.
Yeah, and I've gotten messages and questions around not just do I need to tell my mortgage company, but am I even allowed to put a house into a trust if I have a mortgage? Right.
And a lot of people, and because the trust is revocable and you maintain control and ownership of doing that, then you can. If you get in the world of irrevocable trusts, that lenders a lot of times don't love irrevocable trusts, because when the title transfers, it doesn't name the husband and wife on the title anymore. They've got a third-party trustee that is then on the title. And so all of a sudden the lender's like, wait a second here, loan's in your name and the title just got moved over to an irrevocable trust and you guys aren't even the trustees of the trust, then they can sometimes have a little bit of an issue with that. But on the revocable side of things, as long as they're still on the title, then all is well.
Perfect. So we have funding with the real estate. What's
yes.
the next?
Next one is bank accounts. Now, there's two options when it comes to bank accounts. There's a simple option, and then there's a little bit less simple option. They're both relatively easy, but option number one is you can name the trust as they call it a payable on death designation. So if you go into the bank and say, hey, I want to name my trust as the beneficiary, the bank obviously understands what a beneficiary is, and they'll go, well, technically we call it a payable on death or a POD, or sometimes people call it a POD. So that's a payable on death. And then you just name the trust as the payable on death. So that way the checking and savings account stays exactly how it is. Checks stay the same. Everything stays the same. You're just simply saying, hey, bank, if we die, pay the money to our trust. Which that's probably one of the easiest or most simplistic ways of doing that. Now, the second option is you can change the ownership of the bank account to name the trust as the owner. It does take a little bit more legwork to do that because you're switching the ownership of the checking and savings account to name the trust as the owner. So it does take a little bit more time and effort, and some people like that. Some people don't like it. So in our instruction letter, we give them those two options. We're like, option one, change the payable on death, or option number two, name the trust as the owner. But one way or the other, get it done.
Yeah. Is that changing the checking account or savings account number?
Yes. Well, It depends. Some financial institutions will let them keep the same account number and then switch the ownership. And then a lot of them nowadays are like, well, if you want to switch the ownership, we're just going to set up a brand new trust bank account, has a new checking account, new numbers,
checks, new everything.
New everything.
Yeah.
And then the downside of that, or I shouldn't say I guess it is a downside. Then for people that do like auto draft, they then have to go back to every single company that they've got that auto draft set up with, and then give them the new account number. So it's that's why I say there's a little bit more pain that goes into that aspect of things. But again, it's not anything too crazy.
This is why I love this though, because that's like the real life application of what we're talking about. Because so much of what I've seen is like just high level, oh, you've got to fund your trust. Well, what does that mean?
Right.
That's what the question that comes to my mind. So we're going through that right now. But,
Yep.
Okay, we've got real estate, we've got bank accounts.
Brokerage accounts. Brokerage accounts is the next one. And brokerage accounts are really very similar to bank accounts. Now, when I say brokerage account, sometimes people have a little bit of a misunderstanding of what a brokerage account is. And they go, oh yeah, I have an IRA. And I'm like, well, that's technically a retirement account. That's not a brokerage account. A brokerage account would be you've already paid taxes on that money and you're investing it, Charles Schwab or Morgan Stanley, or you've got a broker that's buying, selling stocks and bonds, and you are going to be paying taxes on the increase each year. So that's a brokerage account. And people go, oh yeah, we have one of those. Or some people go, no, we don't. But it kind of goes back to those same two things, or those two options with bank accounts. So when you have a brokerage account, you can either update. Now, they call it a TOD. So instead of it being a payable on death, it's a transfer on death. Same principle, though. It's basically the account stays the same. When you die, it transfers to your trust as that. So you just have to name the trust as the TOD, or the transfer on death. Or the other option is you can change the ownership of the brokerage account to name the trust. So those are really kind of the same options. So if you've got a brokerage account, it's very similar to like a bank account because we're not dealing with taxes on doing that. So that's the third one is brokerage account. Then the fourth asset that goes in the trust is life insurance. Now, a lot of people ask and they'll go, well, I already have my spouse named as the primary beneficiary on my life insurance. Can I leave that alone? So that way, if I die, it just goes to my spouse, or if my spouse dies, it comes to me. For the most part, the answer is yes. Unless they have a lot of money and all of a sudden that insurance is going to push them over the federal estate tax limit, then that's not going to be a good option to leave each other as the primary beneficiary. But by and large, for most people, aren't passing away with that type of money like gobs and gobs. Like right now, it's a little over $13 million is the federal estate tax exemption. So most people are not dying with that kind of money. We all wish that we were in that category, but we're not. And so you don't have to worry about that aspect. So most people will just leave each other as the primary beneficiary if they're married. And then they just name the trust as the secondary beneficiary. And then people ask this is the question that I get all the time, and people go, well, I've already named my kids as the secondary beneficiary. So I've got my spouse as the primary, and then I've got all of my kids as the secondary. Can I just leave that? And then we ask this question. We go, how old are your kids? And they go, oh, I've got a 2-year-old, a 4-year-old, and a 7-year-old. And we're like, okay, so you realize that if you guys, let's say you guys got in an accident and passed away, All of a sudden, life insurance goes, we're supposed to pay the money to the secondary beneficiaries, and we've got a 2-year-old, a 4-year-old, and a 7. You can't do that. They're minors. They're not they're not adults. They're still under the age of 18. So then they have to go to court. They have to appoint a guardian and a conservator to now manage that money. The other problem with that is as soon as those kids turn 18, that money gets handed that. And life insurance, those are typically larger sums of money. So all of a sudden that child at 18 gets a big chunk of change and they're like, I don't need to work anymore. I don't have to go to school or whatever. So it can create some issues with that. But even if they do have adult children, so let's say that we have a husband and wife and they're like, yeah, we've named each other as the primary beneficiary and we have our 3 kids. They're all adults as the secondary. Can we just leave that? And the answer is yes, as long as your kids are alive and mentally competent when you pass away. And people go, well, what do you mean by that, alive? And I'm like, well, let's say one of your kids got in an accident and you forgot to update the beneficiary designation to reflect the death of that child. So all of a sudden, you 2 pass away, your surviving 2 kids go into the life insurance company and say, hey, life insurance company, mom and dad have died. We need you to release the money to us 50-50. And the life insurance goes, wait, our beneficiary designation is showing you 1/3, you 1/3, and a sibling 1/3. Where's your sibling? And they're going to go, oh, they passed away before mom and dad, so just split it between us. And they go, we can't do that. We have to follow the beneficiary designation, and that 1/3 is supposed to go to that sibling. But now that sibling's dead, we can't release the money, so it's going to have to go to court and go through probate. So then all of a sudden the kids are, it gets frustrating for those 2 surviving
I think
kids.
this is really important, though, to point out, because you said if you haven't updated it, and we've talked about it a little bit, but I think so much of this is I'm going to set up my trust and I'm good. I'm just going to forget it. But things happen.
Yeah.
And so updating that is an important thing.
Exactly.
To make sure you pull that out every, few years and review what's going on.
We follow up with all of our clients every 3 years.
Okay.
So every 3 years we follow up. But I tell people to get in the habit. I know this sounds so like morbid, but we like to tell people, I'm like, every year when you're doing your taxes, just pull out the trust and thumb through it. Make sure that everything is still the way that you want it to go. And if it's a husband and wife, I'll say it doesn't hurt to go over the exercise of killing each other off hypothetically. And I'm like, I know that sounds so morbid and so random, but you would be surprised, or maybe you wouldn't be surprised, but most people are surprised. A lot of times, one of the spouses runs all the finances. They run the show on everything. And if that one dies first, they leave that surviving spouse and they're like, I have no idea what I'm supposed to do. I don't even know where our assets, I know where the checking account is, but other than that, I have no idea. That's not good. We don't want that. So I always tell people, if you guys have one of you that takes more of the lead in handling the finances, every year, sit down and you kill yourself off, hypothetically, and let your spouse tell you what they would do. It's a good exercise to kind of practice through that. But I know that sounds a little bit morbid. But going back to the life insurance, so a lot of spouses will leave each other as the primary, and then they name the trust as the secondary. So instead of naming kids as the secondary, name the trust. And the advantage of that is the trust never dies because it's a living entity. It's always going to be alive, so we never have to worry about, oh no, somebody died, we didn't update the beneficiary, got to go to court with doing that. So it just makes it a whole lot easier.
That's perfect.
Doing that.
Again, these practical steps I think are invaluable. It's just for me consuming this. This is so awesome.
Good.
So
Well, hey, it warms my heart. I love it.
So now we're past the life insurance. What's the 5th?
5th is retirement accounts.
Okay.
Now this is one we get so many. There's so many misconceptions, misunderstandings, information that's out there. We hear this all the time that people are like, oh, I heard we're not supposed to put our retirement into a trust. We can't do that. And the answer is you can't change ownership of your retirement, because if you have like an IRA or a 401k, that has to remain in an individual person's name.
Yeah.
Because people ask and they go, what if I wanted to, change the ownership? Because we've had some people that have tried to do that. They misunderstood the instruction letter that said, hey, leave spouses as the primary, just name the trust as the secondary. And they go into their IRA company or 401k company and they go, hey, I just set up a trust. I want to change the ownership. And they're like, you're not going to want to do that, because if you change the ownership over to your trust, that triggers a tax event. That'd be horrible. You wouldn't want to do that. So when it comes to retirement, it's really, really important that ownership stays the same. If you're married, it's important that primary beneficiary remains the spouse. And the reason why is spouses get a spousal rollover. So like if I died and my wife, or let's say I had an IRA and I died and my wife's the primary beneficiary, she gets to roll that over into her own IRA and she gets to continue to defer that until, right now it's 73. which that's a huge benefit. So that way she can let that money grow and shouldn't have to pay taxes. And then when she turns 73, whether she wants to or not, then the IRS says, all right, time to pay taxes on that, and they force those required minimum distributions. But that's why we want to leave with married couples. We want to make sure that they leave each other as the primary, so you get that spousal rollover, and then the trust becomes the secondary. And then a lot of people ask and they go, well, I've heard that if the trust is the beneficiary, then it follows a different set of rules on the pullout. Like the money has to come out over 5 years, as opposed to now, if my kids are named as the beneficiary, they get it over 10 years. Well, that's the old rule. Like if you had a trust as the secondary beneficiary before, you were forced to pull that money out over 5 years. Well, in 2019 and 2020, Congress passed some new laws pertaining to the Secure Act. So anyhow, as long as you have that language, which again, we have all that language in all of our trusts, even if the trust is named as that secondary beneficiary, it allows the kids to pull that money out using the required minimum distributions as if they were named on the policy. So that's actually a good benefit as well. But remember, the advantage of the trust is the trust doesn't die. So even if one of the kids passes away, the trust still has those contingencies already built in.
Do HSAs fall within this category? So health savings accounts, because that's kind of a big topic that we talk about a lot on our channel.
Absolutely. And a lot of people, they'll do the exact same thing. Most spouses they'll already have each other named as the beneficiary, and then they just name the trust as the secondary beneficiary. That's the thing, is we always tell people if there's an opportunity for beneficiary designations, most spouses will just leave each other as the primary, and then the trust becomes the secondary. So it's kind of the catch-all that says, hey, if they both pass away, dump it in or funnel it into the trust, and then the trust sets forth the rules.
Perfect. Okay, so we've got retirement accounts.
Yep.
There's one more.
One more, personal property.
Which I think is more than one thing, but
it is.
It's got a lot
personal
going on
property. And this is one that we really probably get the most questions on, is people go, what do we do with my car? Or what do we do with my china? Or what do we do with the musical instruments that we have, or whatever?
They're like wedding rings, diamonds, jewelry.
Yes, jewelry. Those are big things.
Heirlooms.
So those are considered or called personal property or personal possessions. So what we do is we prepare a document. It's called an assignment of personal property. Now, whenever you hear the word assign or assignment in the estate planning world, that's just a fancy way of saying transfer. So when it says assignment of personal property, that means we're transferring your personal property to the trust. But all you have to do is sign this one document in front of a notary, and it automatically transfers cars, furniture, vehicles, jewelry, everything on the inside of your home. And the other kind of the neat thing about that assignment is it takes into account future assets. Because people go, well, what if I bought a car 2 years from now? Do I need to do something different then? And the answer is no. Buy the car in your name, insure it in your name. It's already part of the trust by virtue of the assignment. So it makes it really, really simple for that. And people really like that because I think that's what one of the biggest things that stresses people out. They're like, oh, I'm going to have to go to the Department of Motor Vehicles and change the title. I have to wait in line. That's going to take forever. And it stresses them out. And you don't have to do that. So the personal property assignment handles all of those things. Now, people go, what if I had like a one-off item? They were like, what if I had my wedding ring and I wanted to give it to my oldest daughter? How do I handle that? Well, we do give you a separate document. It's attached to that a personal property assignment, but it allows you to literally handwrite the item and name the person that you want it to go to, and then you just sign and date it. And you can add to that or take away from that at any point in time. It doesn't have to be signed in front of a notary, doesn't have to be witnessed. Literally, just the owner of that asset just indicates, I want this to go to this person, and you sign and date it, and that's it.
Awesome.
Yes, it's super easy.
So we funded the trust.
Yep, funded the trust.
You keep bringing up a notary. So explain that just for
Perfect.
someone like me who isn't super familiar with necessarily. I know what a notary is, but what is the function of a notary for those
Absolutely.
who need
So
to know?
once the documents are done being drafted, first what we do is we email back and forth with a client. So we email them a short summary so they can preview it before we print. And people are like, oh, that's kind of cool. And I'm like, yeah. And they're like, why do you do that? And the answer is just to make sure that everything's spot on. I can't tell you how many times over the years I've talked to people that are like, I had this trust drafted years ago, and there's all sorts of errors. Like people's names are spelled wrong. And I'm like, well, why didn't you tell them that? They would have corrected that. And they're like, well, I don't know. I just didn't really think about it, or that was that important. And it's like, yes, it is super important, because if you get somebody's name wrong, that can foul up everything, or even a middle initial. That it can create a whole lot of problems. And so,
well, and I've got a weird name, so I'm Erik with a K instead of a C, and then my last name is unique. And so every certificate I have, all through elementary school, middle school, high school, they either had Erik with a C, or they got my last name wrong. And so checking, I think, is really important.
It is,
because people assume and they don't look at it.
100% with that. That's actually. Kind of funny. I could totally see
every
that.
trophy, every
Yeah, you're
certificate,
like,
everything,
great.
something is wrong.
Right. You're like, oh, dang it. Anyhow, but that's why we do that. So once all the docs are drafted, we'll email a short summary so you can preview all the highlights, double check name spellings and contact information, and just to make sure that all the right people are in the right positions. And then once we get your stamp of approval, then we get everything printed. We put it in a nice like black leather binder. We put little sign here sticky tabs everywhere, and then we mail it to the client. And then when the client receives that, the first thing that they have to do, I tell people when you receive the binder, it's a 3-step process from there. Step number 1 is you have to get it signed and notarized. Now, the easiest and most common place to get something notarized would be your bank or credit union. That's the easiest place. So they just, and we a lot of times, funny enough, we actually over the years have had a ton of notaries that have actually called us and we've done their planning because the client, the clients that we initially help will go in and meet with the notary, and the notary's like, this is amazing. They're like, we've seen, we notarize a lot of trust, but they're like, this is mapped out so well because literally put you sign here, notary signs here. And the sticky flags actually say all of those things. And so it makes it super easy for them, which is great. But it does have to be signed and notarized, and that's what makes the documents legal and valid. So that's what's happening when the notary is basically saying, I have confirmed that you are who you say you are, and I've done that by either driver's license or some type of photo identification, proving that you were here in front of me. And you showed me your identification, and we signed this together, and I'm verifying that.
Are they doing any sort of like mental capacity check too there?
You know what?
Or is
Good
it just
question.
strictly you are who you say you are?
They could be.
Okay.
And it depends. Now, sometimes every once in a while, we'll get like a husband and wife, and they're like, my husband has kind of got, the onsets of Alzheimer's, and we're just trying to get some of these ducks lined up in a row. And, usually we'll ask them, and we'll say, well, does he still know who he is? Does he know who you are? Does he know who the kids are? And they're like, oh yeah, he knows who we are. Absolutely. But if all of a sudden they went in front of a notary and didn't know who he was, didn't know the document or what he's even signing, the notary's not going to sign it. They would say, you know what, we can't do this. And then they'd have to go to court and get appointed as like the actual guardian through the court process.
Costs are important. Is there a cost to notarize?
Yeah, great
something?
question. I'm laughing because and all those that are in California, I'm sorry because California is just expensive with things. I don't know what it is, but California, even if you go into your bank or credit union, a lot of them will they'll charge either per page or per signature. Now there are some exceptions to that. If you do have a bank or credit union that you've been a member at a long time, then they'll go, oh, this is a service that we provide for our members that have been with us for over X period of time. Or if you're a member of AAA, if people are a member of AAA, they can call AAA and they have notary services as well with doing that. So most people will go into their bank and credit union, and most states, like I said, it's free. That's a service that they provide for their members. But there are a few states that aren't quite as friendly, and they like to charge and make money on that.
All right. Okay, so you said there's a 3-step process when you mail this out. One is get it notarized.
Yeah, want to get it notarized. That's what makes it all legal and valid. Step number 2 is then getting the deed to the house transferred over into the trust. And again, most people will have us prepare the deed because they just want to kind of keep everything under one-stop shop and get everything done. So if we have prepared the deed for you, we already have an envelope. It's stamped. It's ready to go. So literally, they follow the sign here sticky tabs, like sign here, notary signs here. They fold it up, put it in the envelope. They put, and we indicate also in the instruction letter, hey, you need to write a check for whatever the recording fee is, and then they just drop that in the mail and send it in, and the county will record it, and then they'll send it right back to the client. So that part's actually really easy for the clients that have us prepare the deed, because they just literally sign where we tell them to sign, mail it in the envelope we give them, and then it gets recorded and they send it right back to them. So It's super easy with that. Now, if you don't utilize us, then step number 2, you'd have to call a title company and say, hey, we just got done setting up a trust. We need the title of the property to get transferred over into the trust. Can you help us with this? And they'll say, absolutely. They'll ask some questions, and then they'll help them, with whatever their way is to do that.
Perfect. What's step number 3?
Step number 3 is then updating beneficiary designations.
Okay.
So kind of like what we talked about for those. I guess we talked about 6, but the deed is already in step number 2. So really just updating and funding your bank accounts, brokerage accounts, life insurance, retirement, personal property.
Perfect.
Yeah.
Man, that's awesome.
And then that's it.
Do you have to have a will to get a trust?
Great question. And the answer is you don't have to, but
Strongly recommend.
Yes, you want to have both. And I know that sounds so counterintuitive because people are like, well, we just talked about wills and they have to go to court and go through probate. So if we do a trust, why do we need a will? Well, there's two reasons why we do a will. Number one is guardianship. So if you have minor children and you're naming guardians that would step in to get custody, that has to be done through a will. So that's one of the reasons why we do a will in conjunction, that works with the trust. The second reason why we do the will is a safety net document to the trust. Because remember, the whole idea of this trust is while you're alive and you have your signature, we're creating this trust that maps out your wishes, and we're using your signature to move and attach your assets into the trust. So that's the whole idea of this trust is getting all these ducks lined up in a row. But sometimes people forget to do that. Or let me give you a pretty common one. People will set up a trust, they get everything funded perfectly, and then 5, 10, 15 years down the road, they move. So they sell their home, and when they sell the home, it just automatically comes out of the trust. They don't have to do anything. They don't have to call us. We don't have to do anything. It just, by virtue of the home being sold, it's now out of the trust. But where people go wrong is they take that money from the sale of their house and they go buy a different house, and then they buy the new house in their names as joint tenants. They forget to tell the title company that they have a trust. So by default, the title company goes, oh, well, just husband and wife, put you guys on the title of the property. And then if the husband and wife die, even though they have a trust, it's not in the trust. They forgot to transfer it. That's why we do the will. So the will, it's called the pour over will. So pour like P-O-U-R, like you're pouring a glass of water. So the pour over will is used as a safety net so that if anything was accidentally left out of the trust, yes, it still has to go to court and go through probate, but in the probate process, it's telling the judge, hey, we have a trust. We have some very specific rules of how we want this money getting to our beneficiaries. So even though we left this house out of the trust, we want it poured over into the trust so that everything gets distributed the same way according to the rules of the trust.
Awesome. That was really well explained.
Good.
Thank you.
Good.
Yeah,
Good.
It just seems like you is that same thing with like a car? If I go buy a car outside of it, or if I
so the car falls under that personal property,
that's right.
And so when you sign that one document, it's already taken care of. So you never have to think about you never have to think about that again. So it makes it super easy.
No, that's perfect. We have talked about wills, doing nothing, wills, trusts. What else is part of an estate plan? You've hinted at a couple of things, but what else makes up a complete total estate plan?
Great question. There's 10 documents that we prepare, but usually when most people would say, what are the documents that entail a complete estate plan? There's typically like 5. Your trust, will, your financial power of attorney, medical power of attorney, and your living will. Those are typically the big 5. Again, we prepare all of those, and then we have some additional documents that come with that, with making sure that your trust gets funded the proper way, and we have all the instruction letters for banks and credit unions, life insurance. We have all of those. So there's a few extra documents that we put in there that are really, really important, just to cover all of those like crazy worst case scenarios with doing that. But by and large, those 5 are the ones. So we've talked about the trust and the importance of that. We've talked about the pour over will and why we use that. And then people ask and they go, well, what's a durable power of attorney? Or what's a healthcare directive? Or what's a living will? We get a lot of questions about living will because it sounds so much like living trust. People are like, hey, I want to do a living will. And then we're like, okay, so that's the one that deals with being hooked up to the machine on life support. And they're like, no, I want the one that deals with how my assets get distributed when I die. And we're like, oh, that's a living trust. The living will is the one that deals with being hooked up to the machine on life support. But we'll talk about that in just a second. But the financial or the durable power of attorney is a financial power of attorney if you're incapacitated. That's the key right there, is if you're incapacitated and you're unable to take care of your finances or do anything legally for yourself, you're naming somebody else to be able to step in and do that for you. It's important that I mention this. There's 2 types of powers of attorney. Well, there's probably more than 2, but a lot of times they fit into one of 2 categories. You have what's called an immediate power of attorney, and you have a springing power of attorney. And people go, what's that? Well, immediate, obviously, that one's pretty simple. They go, okay, well, as soon as I sign that document, I am immediately authorizing whomever I've named to now step in and take over legally or financial. And the answer is yes. So that's an immediate one. The ones that we typically do that are more popular is what's called a springing power of attorney. And what that means is 2 doctors have to certify in writing that you're incapacitated before that authority springs forward.
Okay.
That's what's called a springing power of attorney.
I was going to ask, like, what defines incapacity?
I saw that in your eye there. I saw that. You're like,
yeah.
Springing power of attorney. Okay, so, but anyhow, that's normally what we do because we want to make sure that like myself, while I'm alive, I don't need somebody else to be able to do that for me, and I don't want anybody else to have that authority to do that. So while I'm alive, I'm in full control of everything. But if something happens and 2 doctors certify that I'm incapacitated, then, I've got my springing power of attorney that says this is who I'm authorizing to now step in and take care of everything legally or financially.
Awesome. And that was one where the definition of incapacity is the question that I had as well, of like how do you know when that is or isn't? But you
2 doctors.
Right?
The only exception is, funny enough, in our documents it talks about that, where 2 physicians have to certify in writing unless it is something where somebody is they are in a coma. And there's no question, and it could be 1 doctor that says, no, they're in a coma. We've got them on a ventilator. And you don't need 2 doctors to certify, hey, they're in a coma.
Yeah. I think we are transitioning into that medical directive or whatever that is. But before we do that, is there anything else from the financial power of attorney that people need to be aware of or maybe avoid?
Don't pick somebody that you don't absolutely trust. Really and truly, the power of attorney, funny enough, I'm going to say powerful. It's one of the most powerful documents because literally, if you sign a power of attorney, you are authorizing them to do anything and everything for you. And you just have to make sure that you trust 100% that person that you're naming to do that, because literally they will have access to everything with them. So
perfect. Okay, let's move over to that medical directive. I know there's a bunch of names for it, but but whatever you prefer.
Yes, I was going. So typically people call it like medical power of attorney. That's the document that says, hey, if I'm incapacitated, I'm not hooked up to the machine, I'm just incapacitated. This is who I want stepping in and making medical decisions and communicating with the doctors. And then the living will, that's the document that says, if I'm hooked up to the machine on life support, this is my will. That's why they call it a living will. What's your will to live?
Yeah.
I don't love that name because it's kind of confusing, where they're like, oh, living will, what is that? But it's essentially your will to live. If you're hooked up to the machine on life support, do you want them to pull the plug? Do you want them to keep you alive? If you want them to keep you alive, how long? How many days? There's a lot that kind of goes into that. And then a lot of states are transitioning into what's called a healthcare directive, which combines them both. So instead of having a separate medical, separate living will, they're combining them into both, which is really nice. That's actually a really, really nice thing. So a lot of states are moving and transitioning to that. And it's also taking away a lot of that misunderstanding of having to say living will when they don't really mean living will, because they're like, I just need a healthcare directive, and then it encompasses both of those. But those are also really, really important documents. So that way, if you had Alzheimer's, dementia, stroke, senile, you've got somebody that can then take you into the to the hospital. Because a lot of people have that misconception and they go, oh, I need a living will because I'm going to be hooked up to the machine on life support. Well, you may have Alzheimer's or dementia. My dad had Alzheimer's and dementia, and he wasn't hooked up to the machine on anything, but we still had to make decisions. And so the doctors would step in and communicate with us because he had already signed that document allowing us to do that.
How specific does that one get? Is that something where, okay, the person who is in charge of executing the will to live, is that where, okay, I'm incapacitated, they could do what they want? Or is that if I am shown to not be able to have this amount of standard of living, then that's when we make a decision? Or if I have these diseases, like how specific can we get with
It's interesting. And every state's a little different. That's the one document that is, every state is completely different. I mean, really and truly, they're totally all over the board. Well, I shouldn't say all over the board, but they're just totally different with some of the language that each state utilizes on that. Because some you can get really specific. Like you will literally go in and they'll say like, you have to initial yes or no to this question. If you are in this situation, yes or no. Or if you're in this situation, yes or no. And it gets really, really specific. And then it really gets into the weeds like, do you want us to give you antibiotics? Do you want us to give you this? And it can get really, really specific. And then there's some states that are a little more, I don't want to say loosey-goosey, but that's the only word that's coming to my mind, where they'll say, yeah, if you sign this living will, you're basically saying that you want us to pull the plug, with doing that. And it doesn't really give you any options. You're literally just like, yep, I don't want to be kept alive if I'm hooked up to the machine on life support and I've signed my living will, and that's kind of it with doing that. But more and more states are transitioning more over to the advanced healthcare directive. That's giving you more of those options, because I think that they're finding out that if it's too just loosey-goosey, it still creates problems, because the doctor's like, well, they've signed this living will, and the family's like, well, we want to keep them alive. And they're like, well, they've signed this document saying you want, to pull the plug. And then a lot of times the doctor will always go off of what the agent is going to be indicating, because the doctor of the hospital, they don't want to get themselves into a lawsuit of being like, I'm the agent and I told them to keep them alive and they didn't listen to me. And then all of a sudden it becomes this big to-do. So a lot of times, even if there is a living will or a healthcare directive that sets like these specific, like pull the plug and do this, then sometimes if the agent is there, they can override that.
Well, and this is again very applicable to our situation, because when my mom got to the point where she was incapacitated,
Right.
there were a difference of opinions on what we should do. And I don't blame the sibling or siblings that had different opinions. It was just very clear that it felt like we were going against what her wishes were for a certain amount of time. But as you said, like, I feel like the hospital's in a weird spot.
They are.
If we don't do what the person in charge is telling us to do, then they're going to sue us. But if we, I don't know.
It's tricky, and it is, and that's the thing, is it's not just totally clear cut black and white in those situations, and it's hard because sometimes it's like we wish that it would be a little bit more like, oh, this, we've signed this and boom, you do this, but there's a lot of variations that are in there that they go, you know what, we got to kind of navigate through this carefully, and sometimes it's frustrating for family and siblings because they're like, this is what mom wanted, yet you're going over here, with doing that. And it's hard, it's really, really hard. And yeah, so I'm sorry to hear that, but that
well,
is
again,
hard.
like you could do all the planning, but like, again, when rubber meets the road and life is happening and emotions are involved and goodbyes and all of that stuff, like things change. So
it does. Yep, absolutely.
It's important. Is there anything that we've missed in this complete estate plan package that people should consider, right? So we've got all the documents we've talked about, all of the trusts, wills, power of attorneys, all of this thing going on.
I mean, the good news is I feel like we've done a pretty good job of covering things from A to Z on what people need and kind of how to navigate through this. Oh, one thing that I do want to mention, people ask all the time and they go, what do I need to know before I pull the trigger and start filling out a questionnaire or moving forward with you guys? There's really 5 key questions that you have to be able to answer. Number 1 is if both spouses pass away, or if you're an individual, if you pass away, who's going to control the money? So you have to know who that's going to be. And that could be an individual, it could be a couple, but remember, they got to be over the age of 18, live in the States with that, but you have to know that. Second question you have to know is, who are your beneficiaries going to be? Is that going to be your kids? Is it going to be other family members? Is it going to be church, charity, foundation, combination of all of those things? You just have to know that. So be thinking about, hey, if I passed away or we passed away, this is how we want things to go. Because when you fill out the questionnaire, it's going to ask you those questions. The third question is guardianship. Now, this is only applicable if you have minor children, but if you have minor children, you have to think about, if we pass away, who's going to step in to actually raise and get custody of these kids? A lot of people ask and they go, could that be the same person as the executor? So that way we've got the same person that has custody of the kids, they've also got control of the money. And the answer is, yeah, you can do that. And then some people go, I don't know if I want that though. I can't, because sometimes they're amazing parents and they're so nurturing and just wonderful, but they're horrible with finances. So I'm like, if you fall into that category, you probably don't want to put the guardian and the executor, to be the same person, because that's just kind of setting yourself up for failure or the kids up for failure essentially. So, but you do have to know that. You have to know who you want stepping in to get custody of minor children. The fourth question you have to be able to answer is, if you're incapacitated, who's going to take over financially? Now, a lot of times, most people pick the same person that they picked as the executor, because most people go, well, if we're dead, this is the person that we choose to handle our finances. Well, if we're incapacitated, we still trust this person to handle our finances. So a lot of times those kind of go hand in hand. It doesn't have to go that way, but that's 9 times out of 10, that's what most people do. And then the fifth and final question that you have to be able to answer is the healthcare directive. So if you're in the hospital, who do you want stepping in to make decisions? And in any of these situations, they have to be adults. They have to be over the age of 18, because they have to be able to sign on the dotted line and do that.
That's awesome. The camera went on me, but we're just going to keep going because this is a better view anyway. They can just look at you rather than me.
Not.
Here's a question I have. I've heard about estate plans and the costs of them ranging into tens of thousands of dollars down to $1,000. So what is the difference between $1,000 estate plan and a $10,000 estate plan?
Great question. My knee-jerk reaction when you just said that is, it depends on where you live If you live closer to the coastlines, your price goes up just by virtue of things being more expensive on the coastlines. With doing that, when I say coastlines, California, Oregon, Washington, or on the East Coast as well, things are more expensive. Or if you live in a bigger city, things are more expensive because, again, to either lease a spot or whatever, it's higher for them, so they're going to charge more on their product as well. So that's the first thing. But the biggest thing is, as you get into some of the really expensive trusts, normally that's because somebody has a lot of money and they really need some advanced planning. Like they really need like an estate and a tax planning attorney that is really in there just diving into every detail and making sure that they've got all the I's dotted and the T's crossed. That's where you can get in, the $10,000 to $15,000 to $20,000, range. But for most people, when they're like, we're relatively middle America, if you will, and we just want to make sure that if one of us passes away, it goes to my spouse. If we both die, it goes to the kids, or some variation where it's it's really relatively simple. There's not really going to be a difference. Like again, all of our documents are state specific, attorney drafted by some of the top estate planning attorneys in the nation anyhow. So the documents themselves are fantastic with doing that. But because of the way that we're structured to do things, where we don't, the attorneys aren't, on there talking and doing that aspect of things, we're just able to substantially cut the cost, but still provide the same end product.
That's awesome. And from my perspective and yours, it's not necessarily if you're living on the coast that you're going to charge them more,
no,
right?
We do flat fees.
Yeah,
that's the great thing is our fees, it doesn't matter where you're at. We do straight flat fees across the board.
That's awesome.
By doing that.
No, I am so glad that, one, you've taken the time to do this and share this with everybody.
Oh, you're so welcome.
Two, that we've been able to meet, because this is a need that I think our viewers have been needing for a long time. So if they do want to reach out, they can always come through me and the Retirement Nerds if you would like to, but also if they wanted to just go direct to you, what's the best way for them to find you?
Easiest thing to do is go right to the website. Go to easylegalplanning.com. So and easy is spelled out EASY. I know you'll probably have that on there, but easylegalplanning.com. Is the easiest way, and all of our contact information is on there. We've got a lot of really neat tools and programs and stuff that we just try to keep things easy, because I know estate planning can feel so huge and overwhelming and just heavy. And we've tried to even with how we navigate through our website, we've used kind of cartoons, so it keeps it a little bit lighter, as opposed to feeling, quite so heavy. So I hope that everybody, feels that way as you do that. But that's probably the easiest way to get a hold of us, is just go right onto the website, and then we'll be ready to go.
That's awesome. And I think, and it's in the Medicare space too, or Social Security or anything, it's the mystery of, I don't know,
Right.
like I hear all these words and people throw them around, and
Yep.
I just don't necessarily what that means to be implemented. And I think you've done such an awesome job of that today, of helping us understand, okay, here's what that word is. Here's what that means for you when it comes to happen in your life. So I can't thank you enough. Thank you so much for being here.
Thank you so much.
And we'll do more videos. I think
love
this is fantastic.
Love it. Thank you so much.
Yeah.
Appreciate it.
Okay.